Show.
Welcome to the Bobby O Show. My name is Bob O. Potzner. I'm an attorney at the law firm of Collins Hannafin in Danbury, Connecticut. I'm an experienced litigator. I've been doing a large part of my practice of law has been family law, and I'm on the executive committee of the State of Connecticut Bar Association on family law. I decided it's time to do some shows on family law, and I want to do it on a certain specific aspect of family law because family law is very complicated in terms of rules and regs. But I want to break it down to one particular aspect, which is called non-adversarial divorce. And I have with me today a superb attorney. She was a litigator, I'm sure, but she's very heavily involved in non-adversarial divorce. In fact, she's the president of the statewide organization called the Connecticut Council for Non-Adversarial Divorce. And I welcome Rosemarie Ferrante. Rosemarie, welcome to the show.
Hi, Bob. Thanks for having me.
Rosemarie, just give us a little bit of background about yourself before we get into the specific topic, what you do, what kind of practice you have, et cetera. And then we'll get to more specifics about non-adversarial divorce.
Okay, great. So as you said, I used to be a litigator. I've been practicing exclusively family law in Connecticut for over 25 years. I was trained in mediation and collaborative divorce many years ago. And for the past 10, 11 years, I've focused solely on divorce mediation and collaborative divorce.
It's interesting because I've always been, until I'd say like the last 10 or 15 years for myself, focused primarily on the traditional model. The traditional model being essentially two clients, two lawyers, 90% of the cases or more would settle. But there's been a development over the years into the non-adversarial model, which you're going to describe for us in a moment, which I happen to think is the way to go if possible. So, Rosemarie, please explain to us what is non-adversarial divorce.
Okay. So, as you said, in a traditional litigation, spouses hire attorneys and the court process takes over. So in non-adversarial divorce, there are two options: divorce mediation and the collaborative divorce process. Both of these processes, while still legal processes, take place outside of court. So they're both private processes whereby spouses meet in various sessions with their team. And the team is different, and we'll talk about the difference between mediation and collaborative in a moment. But the similarities are that there is good faith transparency, full disclosure. So there's no formal discovery like there is in litigation with subpoenas and depositions, but both spouses commit to full and fair disclosure, to good faith negotiations, and to conversations that are forward-looking. And the idea is that spouses who started with love can certainly end their relationship with respect. It's relationship preserving. And so the goals are to find what both spouses' goals are, what the goals are with respect to the children, and to help this family restructure in a healthy manner, as healthy as possible. And so the team is very important, and we can talk about the difference between mediation and collaborative divorce. But the idea is to make sure that both spouses have the support they need individually and together in all aspects of dissolution of marriage, which is not only legal, but is also financial and emotional.
I think an important point of what Rosemarie just said is essentially in Connecticut, and every state's law is different. We have a Constitution of the United States that mandates certain things, but in terms of divorce law, family law in Connecticut, it's different than New York State and other states. So we're focused upon the Connecticut aspect, although I was initially trained in collaborative by someone out of Vancouver, British Columbia, whose name escapes me, but I'm sure you know who I'm talking about. And the thing is that you have to, in order to get divorced, essentially, you've got to file a divorce action, and you have to have it approved by the court at some point in time. And what has to happen in between is what we're focusing upon in this discussion. Rosemarie, I'm a member, by the way, of this group. And I, of course, in preparation for today's show, I went through the the website, et cetera. And I was struck, and it's like there's a Supreme Court justice who once said he read the Constitution every day, and they said, well, why do you do it? He said, every time I read it, I learn something new.
Right.
And the thing that struck me, Rosemarie, that I kind of should have had memorized is that we have a mission statement, essentially, which has 4 component parts. I'd like you to perhaps discuss them. One is protect your dignity. Second is, and not necessarily in this order, maximize control. Thirdly, optimum efficiency. And number 4, reach an agreement. Those are really good mission statements, I would call it. Rosie, you want to take a couple, and I'll talk some about whatever you want to do. Take it and run.
Sure. So I'll start with the fact that CCND is a multidisciplinary organization. And so our members are all highly trained in mediation and collaborative divorce. And our membership, again, includes not only legal professionals, but mental health professionals and financial professionals, because every divorce touches on all 3 of those things. So I think one of the first things you said was promoting dignified and respectful private processes. And the way that is accomplished is really critical, that people have the emotional support they need. Because as you know, in litigation, part of the hardest part of divorce is the emotional component. And that's typically what fuels the longer drawn out adversarial processes. And so with the right mental health professionals in place, whether co-parenting counselors to help spouses unravel a spousal relationship and rebuild an effective and healthy co-parenting relationship, is really important. There's some of that isn't intuitive, and it is a process. And so people having support in that is really helpful. But also the other piece that's super helpful for people who are going through the divorce process is communication. And we all know that most people who are contemplating divorce have had a breakdown in communication on one level or another. And obviously every family is really different. So having that mental health support in helping with healthy communication through the divorce process really assists in making good legal and financial decisions.
I want to comment that, Rosemarie, because you said some very, very important things. A couple of things are, number one, words matter. Words matter. And I love the collaborative model because, first of all, it takes place in my or someone else's conference room. In COVID period time, we had Zooms, but I still like to have the meetings, in my opinion, better off in person because body language is important. And I think it's a very important thing to know that you can't take back words. And it's a much easier way to control the situation. And it's not the control of the lawyers, it's control of all of us as part of the group. And if you're in a courtroom, you have to go through the metal detector, you got to go upstairs and see marshals and whatever. And when you do it in a lawyer's office or a mental professional's office, that's really important. And the other thing is that there are certain things that we as lawyers, although I sometimes say we are, quote, amateur mental health professionals, unquote, but we really emphasize the word amateur. And you do need, in many cases, to have a mental health professional involved. We use the word coaches, but that's an important thing. And I want to mention that I had a case that was a collaborative case with another lawyer who's collaboratively trained. It involved a case in which, unfortunately, the parties had lost a child. And both the other attorney and I knew it was going to be a highly emotional divorce process, even though it was collaborative. And we invited the mental professional to every single session. And it was really helpful because that person, Jennifer Champagne, happened to be the mental professional we used, and that's someone that Rosemarie knows and is a member of this group. I think Rosemarie was also, Jennifer was the president a few years ago of this group. And it was so helpful to be able to turn to the mental professional and say, gee whiz, help us. Or sometimes she'd jump in and say, well, I'm going to help you, even though you didn't say it. Any comment about that, Rosemarie?
Yeah, I agree with you. It's absolutely critical. Again, the emotional component of divorce can't be removed. What do they say? Divorce is the second most stressful event in one's life following the death of a loved one. It's highly emotional. Regulating those emotions, again, it's a learned skill. And so having mental health professionals who can really help guide that is so important, and a critical role in collaborative, which is very different than litigation. So should we break down what a collaborative divorce process is? Would that be helpful?
Why don't we do that? I just want to say one quick thing, and that is the training aspect that you mentioned is really important. And we have lawyers who sometimes will say, you have to be technically collaboratively trained with a collaborative process. And Rosemarie goes to more than I even, I'm sure. I've been trained. I go to sessions. I belong to groups at once a month, the first Wednesday of every month. The one group I belong to meets, and we have lectures and speakers and discussions and cases, whatever. So it's a constant, ongoing training, even more than the Connecticut requirements for continuing education. But yes, Rosemarie, why don't you break it down for us? Appreciate that. Thank you very much.
Sure. And just on that note, CCND has our members ascribe to certain standards. And so those standards are different models of standards for mediators and collaborative divorce professionals, which are all on our website. But in a collaborative divorce, and I want to jump to something you said. I hope that I'm doing this in an articulate way, but you had talked about starting an action in a litigation where somebody is served. Even though a court does ultimately have to approve your final agreement, in a collaborative or a mediation process, you and your spouse will know that agreement inside and out by the time you get to signing, because you've made those decisions. You've worked with your team, you've gathered the information, you've become educated on all of the options, because we've built the options for resolution together during these processes. And I just want to say that it's not until you sign that agreement that the court even knows a divorce is happening. That's when we file. And not only are we filing to start the action, we're filing the agreement and the financial affidavits, and we're asking the court to enter judgment on divorce at that time. So
I didn't say the word served. I said it's got to be started. And yes, many cases are done where it's all bing all together. But there are other cases, even collaborative cases, where sometimes it's not that methodology exactly. But my only point was you got to start it and you got to end it, and how you get to the end of it are different models. And although, Rosemarie, I'm not sure if every single divorce case that's collaborative doesn't have the case started before the agreement's in place. I think it's preferable,
correct,
by far, but but there might be reasons why things start a certain way and not the others. But it's preferred that before someone files the lawsuit for a divorce, that there's discussion about, should we file now? When should we file? And that's part of the process.
That is part of the process. And you're right. And every collaborative looks different, as does every mediation. But in a collaborative, in a pure collaborative, each spouse has a collaboratively trained attorney representing him or her. And there is a mental health professional who's a coach who can also, if there are minor children, help with co-parenting and with parenting plans. And then there's a financial neutral as well. The critical component of a true collaborative divorce is the collaborative divorce participation agreement. And that's often misunderstood. But the concept and the idea is that everyone signs this agreement. And this agreement says nobody's filing with court. Now, again, there might be extenuating circumstances. Maybe this matter came over from a litigation and there's a reason not to withdraw the action. But the concept is nobody's filing anything with court during this process. And in fact, if anybody does, the collaborative is over and the collaborative attorneys cannot participate in litigation. The idea is to create a safety mechanism and a container for this family to keep the process non-adversarial and outside of court.
I have a question. I have a question for what you just said. Yep. I just want to clarify. During the divorce process, whether you started with a lawsuit being filed, and I don't like it being called plaintiff and defendant, by the way, but that's another story. Mm-hmm. But however you start the situation, once the collaborative situation is ongoing, sometimes issues arise in the process for which there can't be an agreement for whatever reason, despite the best efforts of everybody in the room, et cetera. And then the question becomes, well, do we need to file something in court to have the court decide? And at that point in time, if it's got to be filed, if that's going to happen, then that does end the collaborative process. I think we both said it a little differently, but I think we're both saying the same thing, or are we saying different?
Well, I think we're saying the same thing, but we might actually have a slight disagreement because the collaborative attorneys cannot be filing anything in court. And so
right,
it has to go to court. You have to there's an appropriate mechanism for the collaborative team to gather and determine, is this not working? Do these spouses need to go to court? And if so, how are we going to terminate the collaborative and transition this family to a litigation process?
We're saying the same thing. And by the way, when I've had cases where let's say it's teetering a little bit and it may not, what I try to do, and I hope the other attorney usually does the same thing, and say, you know what, guys, let's take a break today. Let's come back another day. Let's talk about it. And then whatever seems to be the issue that's causing consternation, I'll talk to my client off the meeting and say, maybe you don't like A or B or C happening, but it sort of rekindled the idea of we're better off resolving in this room. And I would say 95% of the time when those things kind of teeter, if done well with well-trained collaborative lawyers and a good team of people, you can get back on the trail.
Yeah. Well, and to that point, this isn't easy. Divorce is not easy. Just because it might be a non-adversarial process like collaborative or mediation, this doesn't mean it's easy for the spouses. There's a lot of hard discussions. There's a lot of emotions. And so while sometimes the spouses might not feel collaborative, it's the job of the team to remain collaborative with a focus on helping the family achieve their goals as best can be given the unique circumstances of their family.
And typically we also I do minutes of the meeting. We take turns who's doing minutes of the meeting so that people can see. Usually it's between the lawyers. Here's the minutes, and you share them. Once we make sure the minutes are reflective of what happened, you show it to your clients, whatever, to make sure we get on board. And then sometimes there are times when the lawyers will speak, and our clients will authorize us to do this, where we might have, if Rosemarie is the other side of a case, and I don't consider the other side, I consider us to be a team, even though we're representing different clients, if we are a team, we would talk typically and say, hey, here's what's coming on today. I want to let you know that we're going to be raising something, or my client wants to ask a question, whatever. I want to give you a heads up that might come up in case you need to talk to your client about it. So the lawyers are not going away from the law in any way. We're just doing a creative situation, and we still represent somebody, but we're trying to make sure that disagreements, and if you're getting divorced, there must have been a disagreement to get you to the table of filing for divorce, to try to get all these issues dealt with in a way of conciliation. Mm-hmm. Comments?
Yeah. So, when we talk about the law, we all know, I think, Bob, you and I would agree that there's no black and white in family law, and there's ranges, and we want to make sure that families have realistic expectations, and judicial norms and what a court can do is certainly important. And so that's the collaboratively trained attorney's job, is to make sure that their client does understand what that could be. What does the law say with respect to alimony or child support? But just as important in a collaborative divorce is each spouse's ideas of what's fair based on what they know better than anyone else in the room, which is their family. And so we really build scenarios based on, what are your thoughts? You're right, words matter more so than alimony. It's income sharing. How are we going to support two households? It's setting the family up for post-divorce success, whatever that means to them. And so we ask about those goals very early in the process. What do you want through this process? What do you want for your children if there are children? What do you want for yourself? And what do you want for your relationship with your spouse after this? And we go back to those goals as we're building various scenarios for resolution.
Rosemarie used an important word, goals. And there's a distinction between goals and objectives. And I typically, I don't think you and I have had a collaborative case together, but I typically like to have a big blackboard or roll over sheets, whatever, and we'll start to saying what your goals are from each person. And what I typically do with my cases, and usually it's how we do them, not because I want it, because it works, is I'll say to my client, for example, give me us the goal you have. The client will give the goal. And then we'll say, okay, other party, give us your goal, and we'll talk about each goal. Do you do it that way, Rosemarie, as well?
Absolutely. And sometimes people need to really understand, what does that mean? Because it's not a position. It's not, I want to keep the house. It's, I feel that the house provides the children with some consistency. And if financially viable, I'd like to consider that. Those are two completely different statements. And we're helping the clients identify those goals, articulate them, and see what we can meet. It doesn't mean that person, it may not be financially viable to stay in the home. Maybe there are other ways to provide consistency for the children. But these are the discussions that we're having that are very different than settlement discussions between two lawyers in a litigation.
And you made a very important distinction, which is goals versus positions. And I had a case one time, someone who's a very good collaborative lawyer, and I asked the other party, I said, ma'am, what are your goals? What's your first goal in this case? And the lady said, I want all of the assets of this marriage. And I looked at the other lawyer, and we looked at each other, and I said, well, that's more of a position, and you don't really mean that, do you? Because we're trying to be fair and reasonable. So the person that said, well, I'll tell you what, here's what I want. My goal is to have reasonably all of the assets of the marriage. We ended up saying, you know what, let's come back another time. And then we ended up doing it collaboratively. We ended up settling it, the whole case. But the thing was, because we were in this collaborative model, the other lawyer and I were both able, within our ethical duties, to represent clients appropriately, work it out. And I will say to you, I still do a lot of more traditional than collaborative. And if I have a case with the same lawyer, this is true. If I have the same lawyer and I respect the lawyer, and we like each other professionally and personally, whatever, there's a different air about it when and I can't tell you exactly why, I know why, but it's the different air when it's a collaborative case versus a traditional model. And so people who say to me, well, I'm a collaborative person, well, that's wonderful. Do you have any comments about that, Rosemarie?
Too many, too many. I mean, it is night and day when I talk to my litigation colleagues. The language, the words, the advice, it's completely different. And this is not to say that litigation isn't appropriate and necessary at times. So for anyone contemplating divorce, you know your family better than anybody. You know your spouse better than anybody. You may want a collaborative or divorce mediation, but it takes two spouses committed to that process. And so until and unless you have that, you've got to think about all three and understand and really have expectations. So, meeting with a litigator like Bob to really understand, what does litigation look like? I think there's a lot of misconceptions about that as well. Don't you agree?
When we were talking about today's show, I was suggesting that we need to, explain in a clear, concise way what the process is for collaborative, essentially, because a lot of people in the audience don't know it. And then I wrote the comment in an email saying, by the way, a lot of lawyers don't understand the distinction. We only have a few minutes left, but I want to go into a little bit about the issue of parenting. And we've mentioned somewhat about parenting time, whatever. And I think some of my collaborative cases, we have mental health professional involved, but sometimes the lawyers will say, you know what, why don't you have a couple of meetings? This may be a violation of the rules. Slap me if I'm wrong. But why don't we have a couple of meetings with just the mental health professional and the parties, and let the lawyers not come to that particular meeting? Give us your minutes, because I'm not a mental health professional, and neither is Rosemarie, even though I consider to be a superb lawyer, and she's works for the betterment of the family, as I try to as well. But sometimes I think that's more efficient. What do you think about that, Rosemarie?
Oh, absolutely. In fact, many of my collaboratives, so in each collaborative looks a little bit different, but the idea is that the team understands what the family's needs are. And to do so, the mental health professional absolutely should meet with them without the attorneys. And in fact, even the financial neutral is going to have some meetings without the attorneys. Some attorneys don't like that, but let's recognize they bring such a skill set to these families that we don't have. And sure, we've done parenting plans, and maybe we have backgrounds in developmental psychology and understand certain things. This is their bailiwick, not ours. And while we can get people to agreement on parenting plans, and we can help people with skills on communication, absolutely, the neutrals roles are critical in a collaborative, and they're used differently, I think, in every collaborative, depending on the family's needs.
I had a collaborative case in which one of the parties was seriously disabled. It was sad. What we did was, as part of the planning, which it wouldn't necessarily happen this way in a court, was to have a trust and estate expert
Mhm.
talk about how to set up trusts, how to do certain things to help provide money for this person who was ill, and then knowing that her life expectancy would not be, unfortunately, as long as you might hope, how to sort of work it out so she had what she needed as she needed it. Having a neutral person in this area made it so much better. And in fact, the person who was disabled, I think, felt really good about having us all talk, almost like mishpacha in Hebrew, it's family,
Mhm.
and there's, I'm telling you, there's a sense and of differences in collaborative cases, especially the lawyers involved. It's important to be involved. And typically, if someone says to me, I want to go collaborative, after we talk, and there's often I usually have a consultation with a client who calls, and some people say, I want to go collaborative at the outset, but others you have to explain how it works and whatever. And then they'll say, well, who can you refer me to? And I try to do that. I try to give names of different people that they can choose from different parts of the area. And I'm sure Rosemarie does the same thing, because you want to make sure that both the clients feel that they have lawyers who are on their side, but also lawyers who know when enough is enough. And any comments about that, Rosemarie?
I know you only have a couple minutes left and you wanted to wrap up with a few thoughts, but yeah, no, 100%. I agree with what you said. We have to educate the public as to what a collaborative looks like, but also be cognizant of the fact that every family's needs are different. And so every collaborative is uniquely tailored to what those needs are.
Rosemarie, thank you very much. And by the way, you have earned your milkshake or Halford Sunday at a local place in Richfield. And you're going to come back to my show, please. Can I have a commitment on that?
I would love to.
Thank you. The only comment I want to make was something about the show I did last week, which was I did a show last week with Tara Donnelly, who lost her parents 20 years ago to gun violence. The show we did was about gun violence prevention. And she has agreed to come on my show again on November 8th, talk about the show, about the issues. We did not get a chance to discuss all the different aspects of it. But those of you who thought that show was worth seeing again, please come back on November 8th. Tara did speak to the person whose gun was stolen, and she's going to tell us what the reaction was of that person and how tragic he felt that his gun, because of lack of safe storage, caused the problem. And also, we're going to talk about some things that Tara's doing to try to help families, especially young kids who have lost their parents or a parent to gun violence. Rosemarie Ferrante, I really appreciate your being on the show. I appreciate your expertise, and thank you so very much. And we'll have you on soon again. Okay.
Thank you. Thanks.
This has been Bob Potzer on The Bobby O Show.